Well, thank you all for being here. I know we're still in the middle of lunch, but I do promise we do have an exciting panel for today. We're going to be discussing how much is too much when you're sourcing funds for an EB-5 petition. To my left, I have an amazing group of attorneys, very experienced, and I'm going to have each of them give a brief description of themselves. I'm going to start with you, Nima.
Oh. Hey, everyone. I'm Nima Korpivar. I'm a partner at David Herson and Partners. We're an immigration firm based in Los Angeles and Seattle, specializing in the EB-5 program.
Hi, I'm Genevieve Roman. I'm also an immigration lawyer. I work here in New York City, in-house for a regional center, Extel New York Regional Center.
Good afternoon. My name is Dan Schwarz. I'm a partner at Fragaman Immigration Law Firm here in New York. Been with the firm for about 13 years now, doing all things U.S. immigration, including, of course, EB-5.
Good afternoon. My name is Jinhee Wild. I am the principal and managing attorney for Wild & Associates, based out of Washington, D.C. area.
And I'm Rebecca Singh. I'm a senior associate with Mona Shaw Global, and I've been doing source of funds for a very long time. So we're going to just go ahead and delve right into it. Jinhee, if I was going to go ahead and begin an EB-5 petition and source an investor's funds, what do I look to? Where do I go?
Well, we have, the regulations are fairly broad. It says that the source of fund has to be legal, but it's not that difficult if you have a tax returns and Western banking system, but many of our clients come from areas where they do not have tax returns, and they do not track of where their money is coming from. Many of the small businesses overseas do cash business, so it becomes very difficult to track. And USCIS now is looking at longer and longer time period, looking at the original source of the money. That could be as far back as 20, 30 years ago. And many of the documentation doesn't exist, so it becomes very difficult. It needs a careful planning and careful research.
So do the regs tell us in detail what we're supposed to submit to USCIS? This is based mostly on our experience, right?
Right, right. I mean, it would be nice if the regulations tell you that we want to see 3 years of tax returns and, you know, or 10 years of tax returns, and we want bank records, monthly bank records. It doesn't do that. I think it's more vague, and it just gives a parameter that we can interpret. And unfortunately, as we have seen a couple of years ago with indebtedness issue, the interpretation could be different from what we are interpreting, and USCIS's guidance change. So.
Yeah. So the regs really just say, list basics, foreign records, they'll have, tax returns, not how many years. But my favorite line is just evidence identifying any other sources of capital. So it's very vague. But Dan, we have policy memos. Has that helped or guided us in any way?
We do have policy memos, and those policy memos are, I'd say, essential because they do point us in a direction. I don't know that it's more than that, which is a general direction of go this way. And they shift, as you're going to hear about a little bit on this panel. We think things are one way, and they are for years, and then suddenly they're not. Which sounds crazy for people who aren't in immigration every day, but in other contexts of U.S. immigration, that's how it goes, right? The agency will decide, no more, we're going in this direction. And there doesn't need to be rulemaking, right? So it's new policy memo or old policy memo rescinded, new policy in place, figure it out. So in terms of the policy memos that do exist, I think for me at least, the value and what I try to reference back to immigration a lot is the standard, right? Which is not clear and convincing, it's preponderance, right? And that should be huge, right? More likely than not. And the policy memo even gives an example of even if the adjudicator has reason to doubt, right? If on the whole it's more likely than not that it's okay, it's okay. That's pretty strong language, right? Even if there's a reason to doubt. Still approvable if the facts indicate, you know, some factors that make it make sense. So I really try to emphasize that in responses to RFEs, both in EB-5 and in other contexts where that standard applies, because it's important and it's valuable as you have to appeal things upwards as you get out of immigration and into maybe federal court. That standard is important, and to keep retracing it and reminding the government of their standard and how it should apply to you is important. And just as an example, you know, I think we've all probably seen the RFEs and the notices of intent to deny based off what to us are seemingly minor discrepancies, right? The month that the person started employment or the year from 1999 or 2000 that the person's employment terminated. And there's the notice of intent to deny saying, see, your visa application from 15 years ago said it was 2000, you actually stopped working in 99. That gives us reason to doubt the veracity. When otherwise, we've got the bank statements, we've got the employment letter, we maybe even have the tax returns. So, you know, those factors in the preponderance of evidence standard, I think, is really important for practitioners to remind the government of at each opportunity.
Well, Nima, you know, the regs also state that, you know, we have invested versus actively in the process of investing. Have you dealt with cases where you've had to differentiate, or do you know of any cases where we had to have more documents to show that is this person really actually investing? What's it mean for investors?
Yeah, you know, so with all things EB-5, there's the regulations, there's what the market requires, and then there's the adjudicative standard. The regulations do not require full investment at the time of I-526 filing. This is hugely beneficial for an investor because not everybody is 500,000 or $1 million liquid. Maybe you need to sell a house, you wait for a bonus from work, maybe you're getting a divorce settlement, lucky you. And because the processing times are so long, you have to make a life choice, right? It's maybe 2.5 years before I get into the US. My son or daughter is going to turn 16. I need to get in line even though I'm not liquid. And so the regulations say you need to show you have an intent to fully fund, and then that fund is going to be irrevocably committed. So how do we show intent? As an immigration attorney, I'm not as well versed in securities and contracts law, but the investor is signing offering documents, right? They're signing a subscription agreement, an operating agreement, potentially an escrow agreement that has funding requirements. And in addition, we require a declaration that says, hey, here's where my money's going to come from, here's my funding schedule, here's my signature. And then whatever we identify in that declaration, we want to see evidence. So if you're going to sell a home, well, give us your deed, give us an appraisal, maybe show us you have a listing with a real estate agent. So when you compile all these documents together, you're saying, hey, I'm on my way, let me in. The issue that you run into, though, is regardless of what the regs say, if you're not fully funded by the time your I-526 is ready to be adjudicated, you're going to be denied. USCIS is going to issue an RFE or a NOID requesting full funding, and if you're not there, go home. The other issue you run into is you need to subscribe to a project. And if a project is really attractive, they may not hold your spot for you for a year and a half, right? Maybe they'll hold it for a month, but a project is in the business of getting investors. So maybe you have to go to a second or third class project.
Yeah, exactly. So Genevieve, speaking from the, you know, you're coming from the regional center point of view, do you accept investments, partial investments? Do you hold spots open for investors that, you know, are looking for their second funding?
We accept partial investments, but we don't have people filing 526s on a partial investment. And we try to accommodate investors as much as possible if they've partially funded and they have a strong preference for the project, but we can't really hold spots for people.
Yeah, because it makes it hard for a project to move forward if you don't have all the funding or what you're relying on. So just for us, because we've done this from our experience, for our firm, we create a individualized checklist for our investors. And so each investor has a different source. Not everyone is going to be the same. You're coming from different countries, different backgrounds. I'm going to, Ginny, tell me, how do you go about figuring out what to get from each investor?
That's a good question. It depends on what the investor does for a living, how they gather the funds in the first place. As a EB-5 lawyer, you end up asking a lot of personal questions to your clients that may not have even signed up with you yet. You ask. But I think that what I would like to see from the USCIS is a little bit more common sense approach to looking at source of funds. If you are telling the USCIS, this is an investor who has been an MD, has a cardiac practice, and has been practicing for 30 years. And he is liquidating one of his buildings. You don't really have to ask, what funds did you have 30 years ago to buy a building? I don't usually get RFEs. I had 3 RFEs on source of funds in 10 years of EB-5 practice.
Show off.
I know. But one of the RFE was a client with a multinational company with a multi-million-dollar revenue. He had received a dividend from the company and used that partial part of that to do the EB-5 case. And the RFE was issued asking, with what money did he establish this company 22 years ago? Luckily, we had the answer to that, but we had provided audited financial statements as well as 7 years worth of tax returns in this particular case. So I think that is a very prime example of what is too much.
And affidavits and declarations don't really work in those scenarios.
Not really. Yeah.
Nima, what about, and Dan, do you guys work with multiple sources where an investor has, I have had clients come with 6 different sources. Do you feel that you need to have more documents to show that, yes, these are investors, they have the money for this, or do you try to limit certain documents to each?
Yeah, so multiple sources is unfortunately unavoidable sometimes, although I really try my best to try to avoid it. So if they come with, okay, it's going to be these 5 sources of my wealth that are going to be the 550 or whatever it is with the admin fee, I usually say, okay, we can do that. It's going to be painful. Or is there anything else, right? Is there a home equity loan we could use? Is there something that you haven't thought about in terms of your wealth that maybe we can get a little bit more bang for our buck on a single or 2 instead of 5 sources, because it gets a little bit wild. And if it's wild for us, imagine for the adjudicator who hasn't been sitting with this person for hours mapping it. So it starts to make sense with us when we've been in the weeds. For the examiner who gets it and is looking at it for the first time, it's like, whoa, it's a lot to handle. So we try to take the spoon feed approach as best we can, and a less is more approach in terms of trying to be precise with the documents and limit the documents instead of here's everything, sort through it and figure it out, right? I think that's a bit of a recipe for RFE, obviously maybe. But that's the approach we try to take, and I imagine that's common, to try to dissuade those multiple sources to the extent that you can.
Yeah.
You learn as an attorney, if you send an email and your client writes anything back besides, I understand, thank you, you messed up along the way. Yeah. And so you need to know your audience, right? Yeah. If I have a client from the Middle East or China, I'm not asking for tax returns, right? That's a waste of money. Yeah. If I have a client from India and I try to get them to source where they got all this gold from, we're just going to have a laugh. So you really need to tailor, your document request country specific. And then if we have multiple sources or we have a lot of holes, then it's a negotiation with USCIS. I'm not going to ask you for any more documents. Let's send it in and we'll negotiate. They'll come back with an RFE pinpointing what's available, and maybe we can come up with half the docs. And you're like, look, you were at $1 million, I'm at 500,000. We came up a little bit. You need to approve it. That's kind of the state of play. And you're always going to have an investor that wants to push, even if the documents aren't there. So you go with what you have, and you know what's really important is there's an officer at USCIS that's reading this and adjudicating this, right? If you can tell them, hey, this is what's going on in this part of the world, right? In Turkey, you know, the president is becoming a dictator. Maybe you're not going to be able to get out of there quickly with all your papers, but you want to leave. In Egypt a few years ago, there was a revolution. The banks were shut down. So maybe you have to give cash. Trying to give a context to where this application is coming from is important, because oftentimes if your life is amazing in the country you're not in a rush to come to the US.
Exactly. So what we like to do is give a background. You know, our source of funds memos can be pages. I know a lot, and Genevieve, I'll ask you this and we'll move forward. A lot of attorneys, like literally a paragraph on the source of funds, and there's no way. You know, we give background information. If we don't have the necessary documents, you know, what can we come up with to make sure that this application is going to go through? So we do have a lot of research and background information on our investors, who they are, where they're coming from. So USCIS can have an understanding of, you know, where they're coming from. So Genevieve, I know with you being a regional center, you guys are getting, you know, tons of applications every day. What is your strategy?
In terms of
reviewing, and you know, do you guys review? So do you review do you yourself or you know your in-house attorneys review the regional the source of funds documents coming in?
I review the majority of the 526s that are being filed by filing counsel. We also have occasionally it'll be an outside firm, or I'll co-counsel and talk with our 924 counsel about cases that are a little more complicated, but we provide a review at no cost to the investors, and we think that it really is a best practice for all regional centers. The I-924 specifically asked the question, is the regional center engaged in a due diligence screening of the investor source of funds? So I do think it's important. I think it's good to have just another set of eyes on the applications.
But that is not to say that the filing attorney should rely on you to
Exactly.
Certainly not.
right?
Certainly not.
Yeah. But do you see an array of differences in attorney filings? Are you getting 5-6 pages of source of funds and then a paragraph, or do you guys have a template that you give out? What do
that's a very interesting question. I started doing this in 2011, and I've reviewed probably more than 1,000 526s in that time, and I see a lot of different work product. It's really across the board. One thing I will say that I found interesting is that sometimes less is definitely more. People who provide a lot more information, a lot more detailed descriptions and write-ups may get RFE'd, and people who have a very short few paragraphs, but they include all the exhibits, just get approved. So,
well, I think it's important to say that when I first started on my first EB-5 case was about less than half an inch thick. Nowadays, from the regional center, business documents are about this, and source of fund documents could be 2-3 inches high. So when you are sending a 9-inch worth of documents to the USCIS office, that officer has to take a look at, review all of these things. And we have over 20,000 I-526 pending at USCIS. I mean, these poor officers are being buried in paperwork. So from the practitioner's point of view, if you want your applications reviewed, I actually err on the side of give more than less, but giving more also means more paperwork. So you need to actually have a summary sheet or something with the exhibit pointing to a particular exhibit that you're trying to alert the USCIS officer, and make it easy for them to review that 9-inch worth of documents.
Yeah,
I think that is the most important thing for us as the practitioners to avoid RFEs and make it easier on the USCIS officers.
I agree. I don't encourage less is more. I think the most detailed and thorough information possible, but also certainly a roadmap and cover letter that's very explicit and easy to understand is really, really helpful.
You know, in the same vein, it's interesting to see when you file with different regional centers, the different review, right? So there's some that are super careful and asking for things in addition to what the reg requires, right? Or what the policy, or what we think the reg and policy memos require. And others who take a much different, I don't call it hands-off, but less of an approach. And I think that's fine. It's whatever, that's how people are. But perhaps, and this is where our conversation started, a bit more guidance from this immigration service would help to level that, right? And then we're not having inconsistencies with what officers are getting, with some piles like this and some like this and some like this. And then obviously that's going to mess with timelines and being buried in paperwork, to Jinhee's point. So I think it all kind of relates back to that same issue, where the regional centers have to be cautious, right? You get 1526 denial, then word of that spreads in China, ball game. So you've got to be really careful. And that inconsistency is really hard to manage, I think.
Yeah, I know with our practice, every document that comes in, you question why. Why do I need this application or this document? What's the purpose of this document? If there's no purpose for it being in there, then you don't need it. But everything should be explained. You know, every exhibit that we have is explained and detailed as to why it's evidencing why the source of funds is legal and lawful.
You know, not to interrupt, but exactly interrupting. But, you know, one other thing to keep in mind is sometimes your client has an aging out child and they need the process to take as long as possible. Yeah. They're like, hey, I need you to file a crappy filing so we can get an RFE and extend this out so we can calculate back and my child won't age out, right? And so that's something to keep in mind too. How do I file a poor case but not poor enough that it gets denied, and also the regional center will accept it, you know, on my word or the client's word that we'll supplement the filing at a later date.
Yeah, that's a good point.
I'm here all week.
Well, Neem, I'm going to come right back to you. You know, I know we touched on this a bit, but you know, the whole understanding. I know when we were speaking before that it's the countries that USCIS needs to understand, culturally understand where the investors are coming from. Right? I know you had that. You had your opinion on that one.
Yeah, I mean, you know, USCIS, if you look at the regs, what their examples for documents are primary documents readily accessible in the United States, right? I'm Iranian. I deal with investors from Iran. You know, the idea of a Western banking system or a non-government controlled banking system, that's pretty silly. The idea of capital flight outside of the country, that's not possible. You work in what, you know, is termed a black market, where you find different transfer houses to get the money out for you. You know, and officers don't always know, right? A lot of the officers are actually veterans of the United States. They've lived in the U.S. their whole life. They're not aware of the banking systems in these other countries, nor was I before I got into this. And so it's really important to paint a picture, right? I mean, if you're fleeing Egypt because there's a civil war, you need to explain that, because otherwise you're not going to have tax returns, right? I mean, in China, actually, it's really common for banks to merge and all the other records to be purged. And so we often look to other areas of immigration. You know, in the EB2 and EB3 categories, if your company no longer exists, well, you can get employment letters from 2 or more people. And if they attest that they knew you and your position and your salary, that's verifiable. The regs also say if a document is not available, but you can prove that it's not available, then it's as if the document was there, if that makes sense. And so a lot of it is explaining to the officer, look, we tried. We tried to get these documents. They're not available. I got these secondary docs. Look, my house was in the newspaper, you know. These are all these photos from my business over the last 15 years. I don't have the registration docs. I don't have the bank statements. But look how happy these employees are. I was a great boss, you know? And you got to paint that picture, because it's like Dan said, the standard is more credible than not, right? It's not, you're not convicting someone of murder. And so you just compile all this stuff to get it through.
One thing that I think we all on this panel, as well as most of you out there, we strive to meet the regulations and policies, and we follow it with the best practices in mind. So I would like to hope that USCIS, understand that that's what we are trying to do. So even though you may have doubts, understand that we are trying our best. So if you can give us the guidance as to how better to do it, in your eyes, we would be happy to follow that.
Yeah. Yeah, I know we had, and I'm 100% with Nima on this point that, we just filed a source of funds with, someone from Turkey, and, they're trying to get out the country as fast as they can. There's other issues, and, we're nervous because we're like, well, they can't gather all the documents. The sun is aging out. What do we do? We know for sure we're going to get an RFE, but USCIS is not going to understand from where we're coming from.
And EB-5 is definitely the slowest way to get out.
Yeah. Well, so let's take it back. So I started in 2011 as well, and I remember when we were filing documents. To me, I felt like it was easy, but now as we're going, I feel like things are becoming stricter, and they're vetting these documents more. What do you guys think?
I mean, no doubt. I mean, there's. It's all about, and Nima kind of said this earlier, where the person's coming from, right? So where you've got somebody who's lived and worked in the U.S., maybe he's in the green card process, backlogged for EB-2 India, and says, I can't wait anymore, EB-5, W-2 income tax returns, high five, that's a good case, should be no problem, right? And that's true. That's great, right? And then you've got cases that go further away from that on the spectrum to the cases, and I'm thinking about particularly markets that are, say, exploded, like Vietnam, where the market has changed so much in a short period of time, and the culture has changed from a banking standpoint, where to us, something that's 15 years old is, well, why can't you get that from the bank? Whereas not so much in some of these other markets that have developed so fast, right? And I think immigration is reacting to that and maybe applying a standard without understanding what's available from those particular countries, right? So it's painting the picture in a way that makes sense, giving the context. Vietnam is a great example, but India is too. There's several where getting bank statements from just 15 years ago, again, in the United States, why can't you get that? It's not even close. There's absolutely no chance. And same with property appreciation. How did you acquire that property in 2002? And why is that hard to document? It's hard to document. And you've got to rely on the secondary sources, and the preponderance of the evidence test is what's going to carry the day there.
Well, I think many European countries even, you're not required to keep tax returns for more than 7 years. So if you are having a audited financial statements, those auditors don't keep those records beyond 7 years. And so asking the client to get these documents on an RFE going back to 20 years, 30 years, may be a little bit too much.
I mean, even here in the U.S., we're not required to keep bank statements for more than 7 years. And even as an attorney, we don't have to keep a file for X amount of years either. So I don't know, they can't expect someone else to do that as well.
No.
Yeah, I would add, I took a little informal poll of some of the filing attorneys before this panel, and I was asking, is there anything that they, thoughts they have? And of course, I do think that things are getting more burdensome in terms of what kind of evidence is required, and it's, but the main thing that people out there filing are saying is just they're getting these RFEs for all kinds of information under the sun, and they're like, we want to, as Jinhee was saying, we want to follow the rules, we want to do this right, we want to be thorough. Are these documents really necessary for USCIS to adjudicate this petition? Do they really need this? Because it's very burdensome, and people are jumping through all kinds of hoops to get all this extra information, which really, at the end of the day, what people really need is just some guidance, like something more clear.
Have you guys seen any difference? We do have a new administration that came in this year. Have you seen a difference of? I know we are seeing a difference at the consulate stage, but what about the source of funds stage?
I personally haven't seen too much difference. Again, I don't get RFEs, but that is not an invitation for USCIS to give me more RFEs, though. But I think that, you know, unless we are in a situation where my one and only denial stemmed from the fact that a case was filed before the indemnity issue policy, and then having that case denied was a real jolt into my ego. But I think that if we are going to change policy or enforcement of Izumi or matter of Ho in a different light, after many years of doing it one way and then changing, again, I would like to see a little bit more of a preponderance of evidence standard being applied, and sometimes that suspicion of something wrong or suspicion of that's not enough seems to be a grounds for denial, and more these days on all of the USCIS cases. So I'm not really sure if that answers your question about if this administration is the cause, but we are seeing more hoops that we need to go through, and then easier denials coming out of USCIS as a whole.
I've not seen it in 526s either, but the speed with which we've seen changes in other areas is, you know, cause for concern. Yeah, because it's gonna safe bet that it's going to, right? Just last week, I think it was, they terminated a policy memo of giving deference to prior approvals on H-1B visas and other types of work visas. So after a policy that was about 15 years old of giving deference to try to make things a bit more efficient, gone. Scheduling interviews for every employment-based green card case filed after March. You know, talk about a strain on the local immigration offices and on practitioners and people, right? So I think that you can tell what the environment is at the service and the path that it seems to be heading. And I don't really see a world in which EB-5 can stay outside of that. You know, we're seeing it in all the other visa types and green cards, and we're seeing it at the concept. We've not seen it at the Labor Department, at least I've not, with respect to okay, lucky me, I guess. But my point is that even though we're not now, we're only 10 months in. And I think that those changes are coming.
We have 3 more years to go. So as we're, so we've seen, you know, we are seeing more and more RFEs. Nima, Genevieve, I know you guys have seen one with the actual getting an RFE on accredited investors. Nima, you want to talk about accredited investors and what you've seen with that?
Let's let Genevieve start with that one, because she has the issuer responsibility.
Well, yeah, we've just in the last maybe 2 weeks seen 1, maybe 2 RFEs basically saying, we note that you are a student and you were gifted this $500,000 for your investment. We also note that in your subscription booklet, you marked that you're an accredited investor. Please provide evidence to show your accredited status. So that, I mean, this is, you know, there are all kinds of RFEs issued in error, but these are concerning to us for sure, because as an issuer, so long as we believe we have no reason to, we believe that the investor is providing accurate representations, and we have no reason to think otherwise, we operate based on we will accept those representations.
Do you think it's outside the purview, though, of we're sourcing $500,000, right? And of course we also have to source the administrative fee, so it could be, $50,000. So we're sourcing that already. Is it now USCIS is, should they be coming back and asking about whether or not the investor is also accredited, or should it be the regional center of the project who should be looking at that?
Well, I think I think it may be other agencies that would have an interest in that, but I certainly don't think that it should be really a part of the USCIS adjudication.
I don't see it either. I don't see the relationship to what we're trying to show to get a 526 approval. I don't see the relevance.
Yeah, it seems to me more of a securities
Yes.
questions, but
Exactly.
playing the devil's advocate here, I guess USCIS question would be, eligibility of the investor, of, where, if you are saying that you are one thing and you're not, it goes to a misrepresentation of oneself or another, and therefore the whole eligibility as an investor becomes an issue. Whether or not I agree with that is a completely different thing, but I think that may be where they are coming from.
Yeah, I mean, I think that's a good point, right? It's the same argument that they make with tax returns.
Yeah.
Because you didn't pay your taxes doesn't mean your money is unlawful, right? Because you mark accredited status and maybe you're not, that actually isn't a USCIS issue. We never provide the accredited investor worksheet. We also never provide the list of the other investors in the project. We don't want an RFE for accredited investor. We don't want an RFE for oversubscription. That has nothing to do with USCIS. That's an issuer responsibility. And even if you're not accredited, it becomes a personal liability, right? If there's a project failure, maybe you're not getting paid back. I don't know what that has to do with your money being lawful or not. I think in fairness to USCIS, you don't know what is an issue until you see the case. So you're just going to have a 2-year lead time. But at the same time, when you're an issuer, like Genevieve is or Extel is, I mean, you have securities implications here, right? I mean, you're on the hook for a substantial amount of money, and USCIS is changing the game on you in the middle. Ripple effects, big time.
Yeah. So we have other trends that we have been seeing. I'm going to go through them quickly because I know we are running out of time. But we've seen, we've had the third party currency swaps right now. So we're seeing, they're asking whether or not the person who's been helping with the transfer, if the funds have been, if they've earned the funds legally as well, or if they're actually from an accredited bank. So we've been seeing that. Genevieve, I know you said you've been seeing, whether or not our mortgage has been properly recorded, which we didn't have to see before. We didn't have to show that before.
Yeah, I mean, I haven't actually reviewed these. It's not our investors, but I understand there have been RFEs coming out asking if the mortgage has been recorded. If not, if it was, the loan was paid off before the mortgage could be recorded. People are providing evidence of that, but I think a logical next step might be to ask, okay, how did you pay this off so quickly?
Yeah, and that's just taking it another step further. So others that we've seen are inconsistencies from if you filed, and I think Nima touched on this before, if you filed previous applications, and now they're looking at that, if you filed other visa applications before. So how much do we have to show as immigration attorneys? Do we have to source now our entire investor's immigration history? We're getting RFEs on it, so how far back do you go?
Yeah, this is an interesting one to me. Some of the one Noid in particular that we did a consult on, it was about the months and years in which the person's dad had terminated employment like 4 jobs ago. And he had indicated December 2000 on his DS-160 when he tried to apply for a B visa or whatever visa from the consulate. And then on the resume that was submitted as part of it, it was a month earlier in 2000. Noid. It was a series. I'm not going to understate it. It was a few of those things, but still nothing that, in my view, would create a situation where that money was somehow therefore not proper. It was not from the sources that we said it was. So it's really interesting. We're seeing it in other non-EB-5 contexts too, like sharing of information and database searches that the government has access to and has had access to for years, but is now using it. And I say now, I don't mean Trump now. I mean now in like the past year or two.
Okay, so what I really want to get out there is that USCIS has been changing some of the policies or the way they do things midstream. And Genevieve, I want to get your opinion from being a regional center. Now that we had this issue back in 2015 when they came out with the indebtedness issue. Some clients were getting denied or you had to withdraw. Same thing happening here again with the third-party swaps, currency exchange. As a regional center, how does that affect you?
Yeah, I mean, going back to 2015 with that change, we had a few people that were approved, and then things changed. It was very clear that things were going to be different, and we had one investor who got an RFE, and we asked them to withdraw their application that was pending almost 2 years, rather than take a denial to protect our, and little did we know that those withdrawals are going to be recorded as denials.
Yeah.
Anyways.
Yep.
But now with the swap RFEs, it's a similar situation. We have had a couple people reach out. These are people with children who could age out, who have been pending almost 2 years, saying, can I withdraw and refile using a new source of funds because the third party who helped me with the swap is not willing to provide all this evidence. And that's really difficult for an issuer because that money is already in the project, and there may not be other sources of capital to return their original investment. We've got to use their new investment towards the eligible expenses. So it's a really, really difficult. It's terrible for both sides.
The practitioners in the space are really smart. If you give us promulgated regulations and some logic, we'll figure it out. What is upsetting to me is when you get an RFE for someone using a transfer house and they say, well, the transfer house in country A is not the same as country B. That money, we can't prove that money is the same because they're not the same entity. We can't approve this. That defies all logic in banking, right? If you go into a Wells Fargo in Colorado, you're not going to get your exact same dollars back if you go to the ATM in LA. That's the whole point of the banking system. So I don't know how I can respond to you besides saying, I think you're wrong. What do I do though? I don't have any evidence to prove you're an idiot, So you have to sue in federal court, and then you're costing your client X amount of dollars and X amount of time.
Well, I'm going to finish it up. If you guys have any last points you'd like to make.
I think, again, I feel like beating a dead horse here, but I think that, if we are given a clear guidance and say, from this point on, you shall do this, we're fine with that. But when the cases are being pending for 2 years now, and you're applying the policy that you say today, policy is this, and oh, by the way, the application you filed 2 years ago, we're going to apply it to that one as well, when we didn't know the policy has changed, that's really not fair. And it's not fair to the business that is relying on the funds. It is, it's not fair to the investor who has relied on, and it's not fair to the practitioner who relied on the certain direction that we were given for years' practice. So I think that if you are going to change something, change it proactively as opposed to retroactively.
Mine's going to be the same as what I started with. So for practitioners who are filing RFE responses or source of funds or responding to noids or denials or federal court, it's the standard. It's all about the standard, which is not clear and convincing, and that standard shouldn't be applied, right? It's preponderance of the evidence. We've said it 100 times, but that to me is so important to remind the Immigration Service of that standard, which they've confirmed is just that. And that changes everything in my mind as to how you view the evidence that's handed to support the 526.
Genevieve?
Yeah, I encourage in RFE responses to really hone in on that point of what is the standard. My only other point is that if it's what we need is more clear guidelines for people that are filing, so that people can proceed on a path that they, that they can reasonably rely on, will get them to that approval.
I would just echo Jenny's point that the standard is excuse me, I almost died. The standard is approvable on the day it's filed. It's not approvable the day it's adjudicated. And if there's a 2-year lag, that's on USCIS.
Yeah, and my issue is the inconsistencies. It goes to all of this, but we get one RFE on this, and then another application with the exact same thing, and you're getting approval. So again, it's the educating the adjudicators and telling us exactly what is it that you would like to see from us. And that's it. Thank you all.
No questions.
Oh yeah, are there any questions?
No questions.
You should get that.
we were so good.
Mike?
Do we need to prove the source of the service fee?
The administrative fee? Yes.
Yes. No.
No.
If you cannot do the legal source for administration fee, USCIS will take that amount from the principal and say that you didn't fully invest the full amount.
Yeah. Any other questions? Can you get the mic? We need last question.
But it used to be like that. Like a year and a half ago, you didn't have to.
So I have a question. Say suppose if I want to sponsor a family or a friend who is in abroad, outside of the country. So is it mandated that he has to be a blood relative, or can it also be a PAL?
Oh, you're talking about gifting? Money?
Yes.
Yeah. No, the USCIS has not said that there needs to be a familiar relationship. However, from what I am hearing from other practitioners is that they would like to see some sort of nexus between parties as to why should someone, Rebecca can give me 500,000. Thank you.
I wish.
But they're going to ask, what relationship do you have, and why is it not a money laundering? So we're afraid that they may require that at some point, but they have not.
It has been in prior. They've mentioned it in prior bills, proposals,
Yeah.
that you have to have a familiar relationship,
But
a close familiar relationship. But at this time,
It is
like
not.
Jinhee said, you can gift to anyone as long as you have that nexus.
So my next question related to this is, say suppose if the project gets failed, I mean, for some reason.
Well, can we do this? I know because we're running out of time. Do you want to see us after?
You can just talk to us.
Thank you.
Thank you.